So, legal relations and questions. First question, definition and voice types of legal relations. Yeah, definition and types of legal relations. Then, second question, types. Yeah, definition and types of legal relations. Second question, prerequisites of legal relations. Prerequisites, or causes, yeah, or some circumstances, yeah, prerequisites of legal relations. Third question, structure of legal relations. Structure. And last question, rights and duties in legal relations. Rights and duties in legal relations. So, what do you remember from this topic? Do you remember what is this? What is legal relations? And maybe you remember the structure or some features of legal relations. Yes or no? Oh, sorry. Bless me, yes? Okay. No, don't you remember? I hope that you should know something from your Ukrainian lectures, standard sentence from me. Yes, yes. Oh, it's a surprise for me. So maybe you don't know what is this. Okay, we'll start to learn this topic, and I hope that you will know something about this topic. So, legal relations. About definition. What is this? Legal relation or legal relations, yeah, are kind of social relationship. I think it's obviously, yeah, social relationship. But this social relationship should be regulated by law. It's just legal relation, yeah? And then legal relations are the envelope of personal, political, economic, cultural, and other social relations. For example, all of you are in legal relations with our university. Yeah, why? Do you know why? Okay, in English, because. Mhm. So these legal relations shape our mutual educational activity. Yeah. So transferring some knowledge, yeah, and skills from educators to you. Then next moment about the content, yeah, of legal relations. What is this? The content of legal relations is rights and duties. Yeah, rights and duties of their participants. We'll speak about this content because we have a fourth question. Yeah, we'll speak about rights and duties in legal relations. And now I'd like to say about main features of legal relations. Main features of legal relations. What is this? Firstly, legal relations can arise only in the human society. Yeah, only in the human society. Yeah. Then, second, legal relations arise on the basis of law. on the basis of law. In case of absent legal regulation, there is no legal relationship. Yeah. If you will not have any legal regulation, you will not have legal relationship. Then, third feature, right of participant corresponds the duty of another participant. Yeah, of course, right of one participant, corresponds the duty of another participant. How can we explain this moment? Yeah, another participant should or must. Okay, please. Yeah, yeah, must some duties. Yeah, not prohibited. Yeah, our rightful life. Okay, fourth feature, legal relations are volitional. Volitional. Do you know this word or not? It's just like a will of some person, desire, yeah, of some person. So the will or desire of at least one of the participants is necessary for a rising of legal relations. People enter into legal relations for a certain purpose. For example, to inherit something, yeah, or to take part in elections, or for example, to buy some goods. Yeah, and here we can speak about some will and desire of the participants of the legal relations, and of course, legal relations are volitional in this case. Then, next feature, fifth feature, legal relations arise about the real good. Or we can use here another word, arise about the values. Values. Yeah. Okay. Sixth feature and last. Legal relations are protected and ensured by the state coalition. By the state coalition. Legal relations are protected and ensured by the state coalition. So, coalition. Don't you know what is this? Okay, I'll explain. As a rule, the participants of legal relationship voluntarily carry out their duties. Otherwise, the state is improved to force the opposing party to perform his or her duty. And for example, some person have some duties or rights, and for example, he's tenant. Yeah, a tenant didn't pay the rent charge. And what can we do in this case? The landlord can appeal, yeah, to the court because of this situation. Yeah, okay, need to understand me? Perfect. And next moment, let me turn to the next important moment of this lecture, and the name of this important moment, types of legal relations. Types of legal relations. I'll say about some criteria. Yeah, and then we'll speak about some types of legal relations. What happened? Don't you understand something? Everything is okay. First, classification. According to the subject of legal relations. According to the subject of legal relation. This is criteria, yeah, for some classification of legal relation. So, according to this criteria, I mean the subject of legal regulation, we can distinguish constitutional, administrative, civil. Tell me another types. Public, I mean some branches. Yeah, because public international, if you will say public international law, it will be okay. Yeah, family legal relations. Yeah, we can speak about legal relations in the every sphere of branches of law. Yeah, yeah. Second classification, as to the functions of law. As to the functions of law, maybe you remember the functions of law or not, the name of the function. And something like this, security. Yeah, and that is why here we can speak about regulatory and security types of legal relations. Okay. And so the regulatory ones arise from lawful acts. Yeah, and the security legal regulations arise from the wrongful acts. Yeah, lawful and wrongful. For example, you can speak about marriage contract. Yeah, marriage contract causes regulatory legal relations. Yeah, right and duties of the married couple. It's a regulatory type of legal relations. And committing an offense causes security legal relations between the offender and law enforcement body and the state at home. Okay, perfect. I think this topic is not so difficult, yeah? It's understandable enough. Then, next classification and next criteria for the classification. The nature of legal duties. The nature of legal duties. By the nature of legal duties, we distinguish active and passive legal relations. Active and passive legal relations. What? By nature of legal duties. Yeah, of legal duties. The duty of the person in active legal relations is a certain action. Certain action. What can it be? Can you say what? What? I didn't hear you. Nothing. It's okay. Now you can do some mistakes. For example, to transfer some things. Yeah, or perform a service. Yeah, of course, certain action. Yeah, and the duty of the person in the passive legal relations is to refrain from prohibited actions. Yeah, for example, to refrain from interfering in ownership, for example. Yeah. Okay, fourth classification. And criteria of this classification, it's subordination. Subordination in the sphere of legal regulation. Subordination. And here we can remember our previous topic when we spoke about procedure law and substantive, yeah. But here we can speak about material and procedural right pronunciation, procedural legal relations. What do you mean? According to subordination in the legal regulation, we distinguish material and procedural legal regulation, legal relations. I'm sorry, legal relations, material and procedural. Okay. Then next criteria for the classification, it's the distribution of rights and duties between the parties of legal relations, between the participants, yeah, of legal relation, distribution of rights and duties. And here we can speak about unilateral and bilateral relations. Unilateral and bilateral. Do you know how can we translate these words? Yeah, you're absolutely right. For example, rent relations are bilateral. Yeah, bilateral. Why? Because both tenant and landlord have some duties. Yeah. And gain rights. Yeah, the tenant must pay rent charge and the landlord must provide housing. And security legal relations, as usual, are security. Unilateral. Unilateral. Why? Because the offender bears the duty, yeah, to suffer restrictions of her and his rights. Okay, and I think I'll say about the last classification, but this list is not a finish yeah, list, because if you want, you can open some books, yeah, with the name General Theory of the State and Law, or just the Theory of the State and Law, and in that book you can see many others, other classification, okay, of these legal relations. And that is why, please, you can use these books, and at our future seminar, you can say something about another examples of the classification, okay? Okay, for today, last classification, by the will of the parties. By the will of the parties. The participants, yeah? We distinguish contractual and management relations. Contractual and management. What is this contractual? Mainly, these relations can be in the field of private law. Yeah, and I think you know the definition of the next type of legal relations. I mean management. Yeah. Why? Because these management relations we can see in the public law sphere. Yeah. Okay. So it was our first question. If you want to ask me something, please, you can do it now. No. Okay, second. Yeah, our second question, and the name of our second question, prerequisites of legal relations. So what is this? Maybe you know some prerequisites. maybe you can say about something, and we cannot be in some legal relations without this something. Maybe even someone, but here something requisites. Yeah, of course, you're absolutely right. And the first prerequisite, but we can speak about special, even special prerequisite here. This is the norm of law. Yeah, norm of law. But firstly, I should say about two types of prerequisites of legal relations. Um, there are general and special. General and special. General, it's like material prerequisites, and special, legal prerequisites. What is general? Yeah, general or material preconditions of the legal relations are the following. Uh, Here we can speak about not only of something but somebody. Yeah, and what is this, or who is this? Our participants. Yeah, our participants. Firstly, participants. At least two participants, not only one. Yeah, and we should have two participants or more. Okay, and next, general or material prerequisites or preconditions. It's object of legal relations. Object. So for legal relations, we must have two participants and some object. Yeah, from the general point of view. Maybe you know some examples of the objects of legal relations. These objects can be material and intangible. Yeah, you are absolutely right. So the reason of entering the legal relations may be possession or protection of these values. Yeah, I mean material or intangible value. Yeah. Okay. For example, I'd like to have a cup of coffee. Yeah. And what can I do in this situation? Uh, I'll buy it. Yeah, no, that is all, and it's okay. I'll be in some legal relations with the barrister. Yeah, okay. And special. I think it will be more difficult to understand these prerequisites. Special or legal preconditions of the legal relations. These preconditions are following. Firstly, the norm of law. Yeah, I hope you remember. The norm of law that regulates social relations. If we'll try um, to be in some legal relations without legal norms, I think it will be not legal relations. Yeah, so relations are not legal without corresponding to legal norms. Yeah, for example, mm, my purchase of a cup of coffee is based on the article 698, for example, of Civil Code of Ukraine, contract of retail sale. Yeah, why not? Then, second prerequisite, the legal personality of the participants. The legal personality of the participants. What is this? What do you think? Can everybody will be in some legal relations or not? Yes or not? Okay, maybe we have person under the age of 18. Yes, of course, but not the all, yeah, legal relations. They cannot be participants of all legal relations. Yeah, or for example, mentally disordered or intoxicated persons. Yeah, and here we can speak that this person cannot be participants of legal relations in a whole sense. Yeah. Okay, they then don't have some capacity to enter to legal relations, where their capacity can be limited. Yeah, you said about these moments, of course, some limitation, and in this case, they can be participants of some legal relations. Okay, any contracts that are made by a person who are lacking in a legal capacity are voidable. Yeah, that is the party who needs to protection can seek to avoid the contractual liability. Then, third, yeah, requisite, third requisite, it's legal fact, legal fact. Or factual composition. Factual composition. And here we should understand what is this. Maybe you remember or not. Huh? Yeah, you are absolutely right. So some events, yeah, or acts. Perfect. You know this, but okay. We'll speak about this facts, legal facts. But what is legal facts? We have it's only events, yeah, but acts is are not. Yeah. Yes, it's types of legal facts, and I asked about legal fact, the definition of the legal facts in a whole sense. It's not so difficult. Something like this. Legal facts are specific life circumstances stipulated by law. Yeah. Life circumstances, but stipulated by law. Okay. Law connects with emergence, change, or termination of legal relations with legal facts. It may be some event, you said about this, some acts, and here we can speak about some incident if you want. Yeah, it can be legal facts too. Then as a fact is something that has already been done or an action in process. I think it's important moment. Yeah, the fact is already been done or an action in process. It is an event that has definitely and actually taken place. Then another moment. Let me turn to the next idea of this lecture. Legal facts in their diversity. Yeah. So legal facts are diverse and they reflect the amazing diversity of human life. Are diverse. Yeah, diverse. So we can divide legal facts, and legal facts are divided into events and actions by the voluntary basis. Events and actions. What is this? Again, we can give some definition to the events and actions. And here you were absolutely right that it depends on personal's will. Yeah, personal's will. So, events are legal facts that don't depend on the personal's will. And for example, yeah, of course, we can speak here about force of nature. Yeah, birth or death of human being, and so on. Events we can divide to, and events are divided into absolute and relative. Absolute and relative. And what is this? Absolute events are not connected with human behavior. Absolute events are not connected with human behavior. And here we can speak about earthquake, yeah, that, for example, destroyed some houses. But relative events are still related to the human behavior. Yeah. For example, we can see some fire. Yeah. And at the same time, we can speak about this event like absolute and relative. If we will speak about absolute event, for example, this fire will be like the process of combustion, yeah, is free from human control. But if you will see fire and it will be arson, yeah, arson. Of course, in this case, this is the relative event. Yeah. Okay. Perfect. Because it depends on the human will. Therefore, the fire causes by lightning strike. What is this? Absolute, of course, event. Yeah. And the fire that rose the result of the arson, of course, is a relative event. Okay. Then actions. Yeah. We said something about events, and now about actions. Yeah. Actions are legal facts too, of course, and these actions depending on the human will. Yeah, depending on the human will. Legal action is defined as judicial proceeding brought by one party against another. For example, one party prosecutes another for a wrong done, or for protection of the right or prevention of a wrong. And a special kind of action, the next moment, is fact status. Fact status. What is this? It's like lasting actions. Lasting actions. For example, it can be marital status, yeah, or citizenship. Okay, if you understand, it's good. And then legal actions are divided into two groups. Legal actions are divided into two groups. It's intentional and unintentional. Intentional and unintentional. I think it would be very important information for your future learning of criminal law. Yeah, intentional and unintentional acts. So, intentional act is a lawful action in order to achieve a legal result. What can it be? We have some intention, yeah, and we can get some result. Hmm? Don't you know what can it be? Something like this, yeah. Intentional. For example, we want to have some contract, yeah, and as a result, we will have this contract. Yeah, why not? Or some will or judgment, something like this. An unintentional act is a lawful action that has led to legal consequences, irrespective of the person's will. For example, some scientific discovery or a creation of some artistic products or finding a lost thing. Yeah, it's unintentional. Unintentional. Or you will find some treasure trove. Yeah, it's unintentional legal action. And next type of the our legal facts, illegal actions. Illegal actions or offenses. Yeah. And again, we can divide illegal actions to some groups. And for example, first group, by the degree of social danger. Yeah, by the degree of social danger. Here we can speak about misconduct and crimes. Yeah, misconduct and crimes. I think it's understandable, or I should some explain? No, understandable. Okay, then next group of illegal actions by the object of encroachment. Do you know what is encroachment? No? Yes. Yeah, you are right. In Russian, посягательство. And in Ukrainian, посягание. Yeah, посягание. Yeah, by the object on encroachment. We distinguish offenses against a person, against property, against public safety, against public order, and so on. Against state even. Yeah, it's some classification of these illegal actions. I should say that it's just first steps of the of your future learning the criminal law. You should know this information before you are starting to learn criminal law. Okay, and then Next, or third group, we can speak about the classification according to the types of legal responsibility. Types of legal responsibility. And here we can distinguish, yeah, administrative, then criminal offenses, yeah, then yeah, like our branches of law. But if you will try to speak about the labor law, here we can speak about disciplinary, yeah, not labor offenses, but disciplinary, yeah, okay, and constitutional, international, civil, and so on. Then next group, by the form of guilt, by the form of guilt. Here we can distinguish international and negligent offenses. International and negligent. Then, if you remember, I said that we have not only legal facts, but factual legal composition. Yeah? Yeah. And what is this? Legal composition or factual composition. This is the set of legal facts. Yeah? This is the set of legal facts. We need to the legal result, to some legal result. And they are divided into simple and complex. Do you remember this information or not? Yeah? Perfect. So simple factual composition includes facts from a separate branch of law, and complex factual composition includes facts from the several branches of law. Okay, I think it's understandable, and I shouldn't speak about this so long. And next, a very important term. This is complex legal facts. Complex legal facts. What is the difference between factual composition and complex legal facts? Or one fact? Complex legal fact. Don't you remember? No? No. Okay, factual composition should be distinguished from the complex legal facts, and complex legal fact is a system of sign of one fact. Yeah, and factual composition includes a lot of legal facts. Yeah, or several legal facts. Yeah, you are right. So, for example, we can speak about crime. Yeah, what is this? Legal facts. Legal fact, I mean a complex factual composition or a complex legal fact. Composition. But for example, we can speak about the composition of the offense. Yeah, yeah, you're right. Then, if you have some questions, you can ask me, because it was the last information about our second question. Is everything okay? Yeah, yeah. Then we can turn to the next question, our third question. Third question. So our third question, do you remember the name of this question or not? Yes, structure. Structure of legal relations. What is this structure of legal relations? Yeah, the content. Then, three. Yeah, structural elements. Yeah, subjects, then objects, and content. Content. Yeah, not fact. Content. Okay. So structure of legal relationship is a set of the elements of the legal relations, and they are following: subjects, the object, and content. Content. So subjects. Who is this? Persons or participants. Yeah. So at least two subjects of law. One of them is an authorized person. Yeah. Authorized person, the bearer of right, of the right. And next person is obligated. Yeah. Obligated person is the bearer of duties. Yeah. Of duties. Okay, so second structural element is object, and object can be material and or non-material or intangible. Yeah, intangible. So material values are natural objects, artificially created objects. Yeah, some things, I mean. And for example, natural objects. Here we can speak about water resources, forests, yeah, just earth. Yeah, it's the natural objects, natural and artificial created objects, things. What is this? Yeah, for example. Yeah, cars. Yeah, you're absolutely right. And of course, we can speak here about securities and currency values. And intangible values are personal non-property benefits, personal non-property benefits, and services and results of some scientific, technical, artistic work. And of course, general social benefits and values. Okay, what is this? Personal non-property values. What is this? Personal non-property. No. Personal non-property benefits, life, yeah, health, yeah, honor, dignity. Huh? Yeah, we can speak about human rights here, but it's just personal non-property values. Yeah, because of course we have human rights. Yeah, right for life, right for health, and so on. Okay, then intangible value, services. Yeah, services. What is this? Some result of labor. Yeah, and other activities, for example, in the field of education, I know, domestic services, transportation, so on. Then next intangible value, some example, the results of scientific, technical, artistic work. What is this? I think you know, some literature, works of literature, yeah, books, for example, yeah, and you said about the intellectual property. Yeah. This is this example. We can speak about this example here. Okay, and computer programs, for example, why not? And general social benefits and value. For example, public order, national security, ecological well-being, and etc. Yeah. Okay, perfect. And third structural element of legal relations is the content. Content. What is this? What is this? Okay, we have the actual content and legal content. Yeah, the actual content and the legal content. And distinguish the legal and actual content of the legal relationship. Yeah, what is this? Legal content is represented by the legal rights and legal duties of participants in legal relations, and they correspond to each other. Yeah, here we should speak about legal rights and legal duties. Yeah, firstly. Then the actual content of the legal relationship is the acts, yeah, of the parties to the legal relationship. And the legal content is always typical for a certain type of legal relationship. Okay, and here we can speak about actual content, and that this actual content is always unique. For example, all buyers at supermarket perform legally identical actions. Pay some price of the purchased goods. Yeah, but the actual behavior is different. Why? Because different goods, different amounts of money, discounts, and etc. Okay. Okay. If you don't understand something, you can ask me. No? No. So we can turn to another important part of our lecture. And again, it concerns to the content of legal relations. And here we will speak about legal rights and legal duties. Legal rights and legal duties. What is this? These legal rights and legal duties. So what is legal right? Legal right, don't you remember? No. Maybe some example? Again, we spoke. Yes. Right to life. Yeah. Yeah. Okay. So the definition, the legal right. A legal right is the right which exists under the rules of legal system or by virtue of decisions of suitably authoritative bodies within it. Suitable authoritative bodies within it. Yeah. Or should I repeat this definition? No? What? Okay. Legal right is a right which exists under the rules of legal system or by virtue of decisions of suitably authoritative bodies within it. A person may enjoy a legal right both in legal relations and beyond them. Yeah, I hope it's not a big surprise for you. For example, everybody can exercise a right to freedom of speech independently. Yeah, yeah. Beyond legal relations. Yeah, if you want to say something, you can do it. Yeah, and you shouldn't think you will be right or not right. You think something and you will say, yeah, it will be your right to freedom of speech. And you shouldn't be in legal relations in this situation. And in case of violation of the right to freedom of speech, yeah, affected by affected person, in this situation, we can defend this right in court. Yeah, that is why here we can speak that a person may enjoy a legal right both in legal and in legal relations and beyond of them. Okay, next very important moment. You should understand this because I don't know why, but in exam I can't hear the right answer. I don't know why. Maybe it's so difficult, but attentive. Be attentive now. The content of legal right. The content of legal right. The content of legal right is expressed in three powers. Maybe you know. No, no. You will try to speak about the structural elements of the norm. No. Yes. Okay, you just don't remember now, yeah? Okay, the right to act, one part, one power, yeah, even. Then the right to claim, yeah, and the right to demand law enforcement. The right to demand law enforcement. Don't you hear this information? No, no. Right to act, right to claim, and the right to demand law enforcement. And that is why students cannot remember this free power of the legal rights. Yeah, of course, the right to claim. So, what is this? The right to act. For example, a person having the right to own a thing and has the opportunity to use it. Then to use it, to sell it, and to give it out. Yeah, because it's right to act, right to act. Or the defendant having the right to protection has the opportunity to testify, to file a petition, to bring various arguments to his defense, and etc. So, to right to act. Yeah. And then the right to claim. The right to claim. That is the right to demand certain behavior from the other person. Yeah. If you will have the right to act, we can do something. yeah, with some things. But the right to claim, we have some demand, yeah? And we can demand certain behavior from the other persons. What is this? For example, again, the landlord has the right to demand from neighbors not to hinder the using of the blood and not to contaminate it. Yeah? What is this hinder the using of the blood? You know the translation? No? Yes or no? Perfect. Everybody? I hope. Then the right to demand law enforcement. Fourth, third, yeah, element. And the authorized person can apply to the state authorities for the protection of the violated right. Yeah, in court or administrative bodies and etc. So now you remember these three parts of the legal right. Forever. Perfect.